Area, I throw a salute and welcome back again to Bod TV board, where we dey analyze wetin dey happen and wetin the media talk about. Now, wetin bring me come here, I no clear my own again. Arise news that they don't look the whole thing, they don't deliberate am say something really dey where this INEC chairman dey hide. Why he no one bring those documents where he supposed bring? Why no one bring them come out? And this whole thing constantly linked to say, now this thing government people, now see they control judiciary. So the question I be say, we will get the real verdict, whether we will get the real thing we would look for. The hope we get on the judiciary, it be high before. But from these things we can see now, the thing break my heart. Where? Say the only one thing, the only one weapon we will get, we use and take fight by casting our votes. And at the end of the day, they say we could go tribunal. We can't go. We can't reach the tribunal because they know, say they are in control. Now they build their structure now. Now they renovate them now. Abi, their cars, their benefits, and who they pay them, not be the same government. As soon as I say this matter, it go hard. Because one video was shown about Wike own. He they brag, they went to build the courts, they went to do this one, went to they make the judges, make that they live good life. Then tomorrow Wike can't get court case. Now can't expect me that judiciary come talk against them. It go hard. It go hard. But one thing, I believe in that court where they heaven. That judiciary where they heaven. We know say that one where they heaven, that God own. That one we believe in the conscience, the heart of man. The one where they control man, where be say no man don't already see him as he be. And that one, now go fight this case. Because he passed INEC chairman. He passed every other person we do wuru for this whole election of a thing. That our mandate, it go count. God don't already know what happened that day. And not be man, I go fight for us. Now they will they make the mistake. Now God, I go fight for us. How can I watch this video, my people? I will still not against on a BOD TV board where would they analyze the trends of what they happen. When I do well, bye bye.
The presidential election petition court on Tuesday consolidated all the petitions against the election of Bola Ahmed Tinubu as Nigeria's president. Tinubu and the APC opposed the issue of a merger. However, a 5-member panel of the court held that the petitions would be heard side by side given the time constraint to determine the petition, and fixed May 30th to commence the hearings. In the meantime, the lead counsel of the Labour Party, Levi Uzogu, has accused the Independent National Electoral Commission of withholding essential documents to be used for the hearings, alleging that the electoral umpire is probably trying to manipulate the documents before releasing them.
Why are they holding on to those results? Is it not for manipulation? Of course it's for manipulation. When they are done with manipulation, they will not release them. If they have nothing to hide, why not release all the results? Why not release them? Even 1 month after the election. Why is it so difficult for INEC to release results rather than playing one prank or the other? You know, until we get into trial, we are going to expose them.
Well, let me take a Twitter reaction from Fatima, who wrote, Dr. Levi Uzogu, SAN, has mentioned what I fear most about this INEC shenanigan. I won't trust any document coming from them. They are certainly all cooked by now. 3 full months. How the court is keeping silent over this brigandage is simply beyond me. What a country. I mean, Dr. Levy had said that, INEC was claiming that they haven't paid for the documents, and that is why INEC has not released those documents. This is quite unfair, Dr. Abati. I'd like for you to comment on that particular issue.
Very quickly, I mean, INEC has a responsibility in this matter to make whatever the parties in the case need, so as to not give the impression, as has been alleged, that INEC is partial, is biased in the matter. This is regardless of the fact that the presumption, of regularity in election petition cases is on the side of INEC. That's number one. Number two is a concern that has been expressed about time. Now, if the court says, well, the pre-hearing processes have been concluded, because that's what they mean by saying, okay, we have concluded pre-hearing. Now, from May 30, come and present your cases. And they are saying they will not take witnesses, physically. So what the court is trying to do is to see how they can fast track the process. But even then, the court cannot act outside the purview of Section 285 of the Constitution, which deals with the frames, the time frame for cases. So they have till September 16. What Section 285 says is that you file your matter within 21 days. But what is even contentious about this time frame is that, it includes Sundays and public holidays. And some lawyers have argued that the Section 15 of the Interpretation Act, does not include Sundays and public holidays. But in this particular case, there isn't, that distinction. So you are likely to have this matter going on up till September 16. Now, 180 days. After 180 days, if there is any appeal arising therefrom, the appeal to the Supreme Court has a space of 60 days. So this matter, the way it is, once they start presenting their arguments on May 30, we go on to maybe January, February, by which time Bola Ahmed Tinubu will have been inaugurated on May 29, and understanding the implications as a seasoned politician, he will have appointed people, he would have, if I could even appoint new persons to the Supreme Court ahead of the matter. Which is why you could say that the people who are arguing that, look, we have to take a second look at Section 285 and Section 15 of the Interpretation Act, they may well have a point. And they continue to cite the example of Kenya. In other words, election petitions should be determined before inauguration. Because after inauguration, you see the momentum. 65 heads of state are coming for the inauguration. Blinken has called Bola Ahmed Tinubu. The president of the US, Joe Biden, has announced a 9-man delegation that will be there. Before Monday, you see delegations showing up. Everybody will be there.
All right.
The Supreme Court, at the end of the day, is a court of public policy.
Well, all right.
They will see how it plays out.
Your Excellency, my dear wife, Your Excellency, the Deputy Governor, the Governor-elect and the Deputy Governor-elect, my Lord, the Chief Judge of Rivers State, my Lord, the Chief Judge of the Federal High Court and judges of the Rivers State High Court and that of the Federal High Court, the leaders of the state that are here, chairman of my party, is a Pararebisi, and members of your council, Mayor of Port Harcourt, gentlemen of the press, ladies and gentlemen. My Lord, the Chief Judge, let me, on behalf of the government and people of the state, most sincerely welcome you to River State for this very all-important ceremony. Where we are today used to be Railway Corporation. And if you look at the back where you have the liaison office, south of the NJC, Railway Corporation used to occupy here. Of course, knowing their dirty nature, they refuse to keep the environment clean. And I've no other thing but to say, okay, since you don't want to stay in a good environment, you cannot stay around us. So I told them to quit. And they have left. They have no choice but to leave. And so we decided to use that part of it to build the liaison office of NJC. And then use this part to build the new complex of the Federal High Court. We want to distinguish our state from what you have in other states. We want to really distinguish our state from what you have in other states. But I would like us River State government and you to have a deal. I would say the deal later here. The deal is something that will benefit the Federal High Court and at the same time benefit the River State government, but for the judiciary. That's the deal I'm talking about. Apart from Lagos, and probably, maybe in terms of volume of work, Lagos, I don't think even Abuja, apart from electoral matters, I think River State is best in Lagos in terms of volume of work as regards Federal High Court matters. The court you have there was built by you people. It was not built by us. But we have a standard. And I'm sure in the next 6 months, when you come here, if you invite me as the former governor, you will see the beauty of this court. Even from the 3D you are seeing, you can tell what will happen in the next 6 months. Now, you see, because I took over this property, that property there is railway. You know what they did? They started going to paint. Painting will not save them. If they like, they should go and bring the best paint and paint. That will not save them. This other property here too is going. Because we have a place where you don't know where criminals are staying. People have property, nobody will develop it. They put shanties. You see all kinds of human beings coming out from there. You don't even know whom they are. I will not allow that. And I know that my successor will also not allow that. So they have made it possible for us. I will sign the paper tomorrow, and then it will become River State government property. Then we'll use it for other things. I like good environment. I don't stay in a dirty environment. So tell them that the paper will be signed tomorrow. No amount of campaign. Oh, he's fighting this person. I'm not fighting anybody. I'm fighting for good environment, for people to live in a conducive environment and put in their best when they are working. The deal I want us to do is this. My Lord, the Chief Judge, seeing where your court is now, what we are building has 8 courts, which means you have 8 judges. 8 judges, if you utilize the 8 courts, and which is quite large. I don't think you want to have up to 20 courts where you'll be running that one and running this one. I don't think so. So if you have 8 courts here, then what it means, what will you be doing with that? So the deal we want to make with you, we, River State government, will build judicial quarters for the Federal High Court. Because I hear you are tenants somewhere, you know, like that. We don't want you to be tenants again. We want to build a befitting judges' quarters for you, and then give River State High Court that area where you have, so that they can build another state high complex, state high court. So that is the deal I want us to it's Yendeba. You see. So that nobody will lose out. I can assure you, if you agree to that deal, before you go, I will show you where we'll build your judges' quarter here in this GRA, so that we can start planning for another state high court building. Because where they are is so tight, and with appointment of judges from time to time. So that is the deal. It's an open deal. It's not a private deal. And I know that you want the best for your judges. Let them not be staying landlord house one day, you know, before the money comes for you to pay their rent. Landlord may have locked the gate, that he has not paid his children's school fees. They can't continue. That kind of embarrassment can come, but it's something we should avoid. So many people say, oh, every time he's building for judiciary. It's not correct. It's not correct. There's nothing I'm doing for judiciary I'm not doing for any federal government agency. Nothing. I can speak to you today. Go to the Navy. Go and see the houses were built for the Navy. Go to the 6th Division. Go to the Air Force. Go to the police. The IG is coming here on Friday to commission the Tactical Command Headquarters. These are supposed to be federal government job, not us. But who are those to benefit from this directly? They are our people. So we don't need to wait. It's like you have a federal road, and the road is very bad. And then you say, well, you won't do it because it's federal government road. Who is going to suffer? Is it federal government or the people who are living here? So it does not make sense. So we have supported every federal government, whether you are from federal government or the agencies. That's what we have done. So people should not say that we're always, even the correctional service, as bad as it takes, couldn't have a Black Maria. The state government has to provide at least 6 Black Marias for the correctional service. It is not state government responsibility. You know, so when people are criticizing that we're always supporting the judiciary, it's not correct. For us, we believe that yes, as Federal High Court being part of the federal government should be able to. But when you go to where they are working, and it's not conducive, and then there are a lot of matters pending, and then you see the judge coming in, oh, adjournment. Why? Because the place is not conducive to work. You can see how water is leaking. I mean, I remember before now, the Court of Appeal, it's just that people forget history. If I show you the picture of then Court of Appeal inside the courtroom, when it's read, they will put buckets inside court. So embarrassing. But at the end of the day, the direct beneficiaries are those who are losing. And these are people. And that's why we said, look, we have to rebuild that Court of Appeal. We have to. And by the grace of God, we have done that. The industrial court, like said by the NBA chairman, of course, but we didn't have it here. And look at the inconveniences of our people traveling from here to Yenegua. And most of the matters, labor matters, 80% of labor matters that are being handled in Bayelsa emanate from here. So we said no. And thank God the former president of the Industrial Court approved that we should build the Industrial Court. And we did. And also build their staff quarters. So we're going to give you your CFO here. So don't think that we can come and pursue you anytime. No. We're giving you your CFO, just like we're giving the Industrial Court. And then too, when you now agree to give us that one, then the way we are building judges' quarters for you, we also give you the CFO. So you know that we are not playing. But I thank you for coming and believe that we are living on Monday, but we are living happily. Happily. I'm living happily because I'm living happily. I'm not on the way to say I will not hand over so the EFCC will not come. No. I'm going to be there live and hand over to my successor, and then I'll enter my vehicle and go to my village and stay because I know we have done very well for this state. Our team, we should go out, be happy. If you are not the type that enjoy your life, from today start enjoying your life, and to the glory of God, we continue to thank God for what He has done in our life.
Now, there's been some controversy over the interpretation of Section 134 of the 1999 Constitution. Some legal scholars believe not having at least 2/3 of all states in the Federation and the Federal Capital Territory, Abuja, nullifies the presidential election results declared by INEC and will form the thrust, of what happens at the Election Petition Tribunal. What's your thoughts on that?
Well, thank you very much. I have spoken so much about this and I wouldn't want to be personal. But I wish to draw the attention to the reading of a document, the requirement of a law. The Constitution is a document, and for you to get the true intention of a particular provision of the Constitution, for instance, Section 134, subsection 2, you have to read the entire Constitution in reference to other provisions of the Constitution. That is where you will get the true meaning. Today, I don't want to specifically talk about Section 134, subsection 2, but to give you other background provisions that if you want to construe that provision, you must also have to look at them to give you what you are looking for. First, let's look at the Constitution itself, Section 1 and 2. And Section 1 said Nigeria should be a federation consisting of the state and the federal capital. That is the beginning. Should be a federation consisting of states and federal capital. That appeared there. If you go back to the sections, Section 3 of the Constitution, it went ahead to list the 36 states of the Federation by name. From there up to Section 6 of the Constitution, you will discover that what is local government is specified, what is area council is specified, the area of the states are defined in the schedule, the area of the federal capital territory is defined in the schedule. So you will know that there's no mix-up of what is federal capital or what is state, because they are specifically mentioned, and the rules of interpretation is that what is specifically mentioned in the Constitution or in a document, what is not mentioned is excluded. So if you look at it, the states are well defined, their territorial area well defined, even their capitals are well defined. If you come to the issue of the federal local governments contained in all the states well defined, and then the Constitution should not pretend in federal capital to say they have a local government, say they have 6 area council, specifically defined in the second schedule of what is the federal capital. Then if you go back to Section 133B of the Constitution, which deals with presidential election, which comes before Section 134, you will see that a person who is a single candidate at the election is still stipulated to win 25% in 2/3 of all the states and federal capital. And it goes to say that if somebody is not elected in accordance with the Constitution, fresh nomination should be. That one has gone further, not talk of fresh election. It says fresh nomination should be taken. That is how serious it is. If you marry that provisions, you'll be able to arrive at the true intention of Section 134, subsection 2. You must look at Section 133. Because the person is just a single candidate, yet the stipulations say you must get 2/3 of yes or no in the 2/3 of the 36 states of the Federation and federal capital. And if he is not elected, there's no winner in accordance with the provisions of Section 133, fresh nomination, not election, fresh nomination should be conducted. That is in the case of a single candidate. So when you come to 134, which deals with multiple candidates, 2 or more candidates, the procedure is almost the same. The and came again. Where it's being argued, maybe rightly or wrongly, that Section 299 makes the federal capital a state. I'm afraid where something is specifically mentioned, well defined, I don't think importation of that kind of interpretation may be appropriate. But that is still left to be resolved by the aspect. But assuming you don't look at that, 299, and equate it, you will see the special nature of the federal character, because there is also specified that the president should act as if he's a governor. And therefore, one may be tempted as the federal capital is created, given a special nature. And if you look at it literally, if he's deemed to be a governor, Section 176 subsection 2 of the requirements of winning 2/3 must have applied. But here the Constitution stipulated it should only be 25%. I thought that is the more proper constitution to consideration. Because if you are saying it's a state, then the issue of requirement of winning to the federal capital by 2/3 as specified in the governorship election will arise. But I don't think that's what is the import of the constitution. But so much has been said, has been repeated about this. I just drew the attention to the other sections of the Constitution that can give more light, because the interpretation rules say make reference to other relevant provisions of the Constitution for clarity. And again says you should read the whole documents as a whole. Section 299 appear to be more consonant with the administrative procedure, which gives the state, the federal capital, the power to the president as if he's a governor to administer the federal capital, and the National Assembly as if it's a house of assembly to make laws for the federal capital. That is my understanding of it. But it has generated so much and it's in court. I'm afraid we'll see what the judges will say.
Definitely, we have to wait and see. But thank you so much for giving us your own interpretation. Now, talking about the presidential election petition court, they turned down the PDP's request for the live streaming of proceedings, saying the request is a new one and is not supported by any law in the country for now. However, confidence in the Nigerian judiciary is low at the moment, with some people believing that justice might not be served over the outcome, of the presidential election. As the former Attorney General of Nigeria, how would you reassure such skeptical minds that indeed justice will be served at the Election Petition Tribunal?
Thank you very much. My previous appearance on this television on the issue of the desirability, I say it's highly desirable but not practicable at this moment. And I gave my reasons, time, and it's a matter of policy. It's not a matter of law. The stipulation of law is that the tribunal should sit in a place that is completely accessible. But you see, we are moving to a society that is highly technologically advanced. Our society is becoming internet-based. It's highly desirable, but regrettably, it's a matter of policy. It is not within the judges presiding. It's not a legal matter. So I think the judges felt that they don't want to go into issues that are not purely legal, but more administrative and more a matter of policy, not legal issues. And I think they were going in the right direction. Again, there's a problem we had never had, it's not desirable to hear you can gauge the social media. But you see things have happened in the country where things are twisted. And at this stage, I think there's more wisdom to say, let us allow people who want to have access to the tribunal to have, but let us not televise. Because before you hear, people will start talking, body language experts will start talking. I saw this judge, I saw here frowning, I saw this. I think these are some of the things that must have created some kind of problems for the judges. Since the applications were not rooted in law, then it becomes a big problem for them to swear. And if anything comes out, who authorized you to rule in favor? On which law did you do it? So to me, I don't still see any doubt in the credibility of the judges. When hearing starts, most of the evidence being presented are documentary evidence. Most of the issues are issues of law. At that time, we can know what is going on. But at this age, I don't think the issue of not televising should play so much important to lower or have effect on the credibility of the noble laws presiding. we should still give them the benefit of doubt.
Bod TV Board. In case the first time you come here, please don't forget to subscribe and hit that notification bell for more uploads.